Representative Evans.
Thank you, Mr. Chairman. In section 10, where it looks like we're cutting out as a proper purpose, if anyone thinks they might have a case, a derivative case, they can't use a inspection of records. Is that the intent?
So sometimes shareholders will use those provisions as sort of an in-run around the discovery process. And so the purpose of it is to make sure that in those cases where litigation is likely, then those documents are discovered in a way that's compliant with litigation procedures.
Well, it looks like you would be if you anticipate any kind of litigation expected to be line 154 and 156. There's not a limit on the ability to do an inspection of records. There's a prohibition.
Well, but in 153 and 155, it constrains those cases to an active or pending lawsuit.
That is or is expected to be instituted or maintained. So that means not just pending, but anticipated, right?
No, my reading is that it's active or pending.
So it's not your intention to scoop up expected claims, and you wouldn't mind if we took that out?
No, I think the language is pretty clear in the way that it is.
My response will be, it makes very clear it's an active or pending proceeding, and that that if it would not be a proper purpose, in my view, to seek information about beyond the actual claim that's been brought. That's fair. Yeah.
I'm not following.
That if and there's an active case that's brought, and the question here is the policy objective is to avoid fishing expeditions which could occur in discovery or seeking access to corporate records that otherwise, which can be a very expensive and delay-causing process. That if for the purpose of seeking information of other potential litigation which is outside of the action that's been filed, that would not be a proper purpose. So I think the language is fine as it is, with that being the policy objective.
But the policy objective is not to cut off anybody who might expect in the future that they might have a claim. I mean, and the reason I ask this is that in Delaware, that you are considering a claim, you still have every right to use their books and records inspection process. And in fact, I think there's even, I couldn't quote it to you, but I don't know if it's an article that I read or a case, but the discussion is sometimes it's preferred that if a minority shareholder or limited partner thinks they might have a claim, if they're able to get access to books and records that tells them that they don't, then it actually saves you from litigation. So Delaware doesn't cut people off from using that process just because, I mean, usually people ask for books and records because they think there's a problem. So if you cut off the ability of people to use it because they expect that they might have a claim, Delaware doesn't even do that. So I just am very concerned about that, because despite what y'all both said, I think the word expected to be is concerning, and that's why I raised the issue.
If I could just add to what the leader said. So lines 154 and 156, that expected to be language is regarding the adversarial named parties, not an active or pending proceeding. So I think that when looked at in that light, your concern is addressed.
Tell me who those parties are. When you said, just say what you said again. I'm just trying to identify who those people are.
Yeah, so, in line 153, an active or pending derivative proceeding in the right of the corporation that is or is expected to be instituted or maintained by a shareholder, or 155, an active or pending civil lawsuit to which the corporation and the shareholder are expected to be adversarial named parties. So in 156, that expected to be language is regarding, who the parties are going to be and if parties could later be brought in.
So how would that, either the leader or you, I don't know how that doesn't mean, if I'm a limited partner and I have concerns that might lead me to a lawsuit, how am I not cut off? Because if I do look at the records and I continue to have the concerns that I have, and I do bring an action, how would I not be in trouble here?
Well, there again, I think the objective here is, as I understand it, shareholders have access to records when for a proper purpose. If it is for the purpose of attempting to create litigation, create an expense and incur an expense associated with obtaining those documents, what I would characterize as a fishing expedition, that's a problem. And potentially, if the law does not provide protections to provide that structure, then corporations will say Georgia's not a place we want to incorporate or be. And so the objective here is to limit proper purpose so that it would not include circumstances where a shareholder is simply attempting to bring a claim, looking for some basis to bring a claim, unsubstantiated otherwise. And this, I think, makes it very clear. It would have to, proper purpose does not include if you have an existing claim seeking records to support some other potential claim outside of the scope of the suit that was brought. That's my reading and interpretation of this as a non-corporations attorney, and it's based upon that I think this is in line with the policy objective I stated.
But you wouldn't, for either of you, it wouldn't be, I don't think you would say it was an improper purpose for a limited partner or a limited shareholder to check on look out for their rights and check on things. And that's sort of where I'm running into the trouble, because if you think you're not going to ask for books and records unless you think there's a problem. And if you think there's a problem, you have to somewhere in your head think this could lead to litigation. But I'm not looking for litigation. I'm looking to see if there's a problem. And so that, I may propose an amendment and it'll be what it'll be, but I have real concern that we basically would cut out, people don't ask for books and records